Hello, everyone, and welcome to the Kentucky Small Business Development Center's weekly webinar. Thank you for joining me today. I'm Dave Etkin. I'm the director here at the SBDC Center in Louisville, Kentucky. So as you come in and get settled, I'd like to take just a few minutes to share some information about the Kentucky SBDC program. The Kentucky Small Business Development Center is a statewide program providing the professional expertise, tools, and information necessary for entrepreneurs to start, fund, and grow their businesses. You know, we do this at no cost thanks to the U.S. Small Business Administration, the University of Kentucky, as well as regional universities, colleges, and local economic development agencies. To learn more, visit us at KentuckySBDC.com, and there you'll find additional resources I know you're going to find really helpful. If you'd like to request personal assistance, you can shoot us an email at info@KentuckySBDC.com or give us a call at 1-888-475-7232. And if you look at the bottom of your screen and if you don't see anything down there, you can hover your cursor over it and the toolbar will pop up. You'll see two features there. You'll see the chat feature and the Q&A. And as we go through the presentation today, if you have any questions, put them in the Q&A or comments, put them in the chat. And just to make sure that you can hear us and see everything well, why don't you go ahead and just say hello in the chat, give us your name and tell us where you're joining from. It's always interesting to see where everyone comes from. We have people from all over the world sometimes. We had somebody from Kuwait last week, which was pretty cool. So there's Shelly popped in from Carthage, Missouri. Nice to see you, Shelly. Thanks for joining. Jacqueline from Lexington. Leo Fonte, my good coffee buddy. If you're here in Louisville, go to Fonte's Coffee. It's excellent there on Lexington Road. Hello, Jonathan. Yeah, a lot of people joining. Corbin. Yeah, good to see everybody, and thanks for joining me today. I really appreciate it. Again, I'm Dave Eck. I'm the director here of the Louisville Center, and we're one of 17 centers throughout the Commonwealth of Kentucky. And because I know you'll ask the question, a recording of today's webinar will be emailed to you this afternoon. It's my role as director of the Small Business Development Center here in Louisville, and when I work directly with clients, I get asked all the time about trademarks and patents and things. So we thought it'd be great to have some real experts come on and share their expertise and allow you guys to ask your specific questions about your situations and get to know them, and they'll share a bunch of resources for you. So I'd like to bring on James Wilson, who will be talking today. James, how are you? He is with the U.S. Patent and Trade Office. Good to see you as always. James is joining us from the Grand Canyon right now. James, I know everybody's interested in this more than you know, so I'm just going to get out of the way and just turn it over to you, and let's just go ahead and get started.
Thank you, David. I appreciate that introduction. Good afternoon, everybody. My name is James Wilson, and I am the Assistant Regional Director of the Elijah J. McCoy Midwest Regional United States Patent and Trademark Office in the city of Detroit. We represent the Midwest region, which includes Minnesota, Iowa, Missouri, Illinois, Indiana, Wisconsin, Michigan, Ohio, and certainly last but not least, the fabulous state of Kentucky, wearing my Kentucky blue today at the Grand Canyon. All right. I am glad to let you know that your questions will be addressed by patent professionals, individuals who are from the United States Patent and Trademark Office, who are sitting, waiting to provide you with the best answers to the questions that you have. Please put your questions in the Q&A and any comments that you have in the chat. And these slides will be posted by one of my colleagues, I believe, and before this session is over. And I'd like to get started. This content, as presented to you today, will be for informational purposes only. The United States Patent and Trademark Office does not provide legal advice regarding intellectual property in these types of engagements. Please consult with an appropriate source for legal authority and guidance on intellectual property legal matters. So the first question that you might ask, or that might bubble up in the thought process for you, is what is the United States Patent and Trademark Office? We affectionately refer to with acronyms. We are also the acronym agency. We are recognized as the USPTO. So the USPTO is one of 12 agencies or bureaus within the Department of Commerce. The USPTO is the federal agency that grants US patents and registers trademarks. The mission of our office is to foster innovation, competitiveness, and economic growth domestically and abroad. We deliver high quality and timely examination of patent and trademark applications. We guide domestic and international intellectual property policy and deliver intellectual property information and education worldwide with a highly skilled and diverse workforce. The USPTO's mission is anchored in the Constitution of the United States, Article 1, Section 8, Clause 8, where it states that the USPTO, or the Patent and Trademark Office, is established to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. A patent is a government-granted monopoly on an invention for a period of time and is useful for excluding others from making, using, or selling an invention. A trademark is a brand name. It is used to identify and distinguish the goods or services of one seller or provider from those of others, and to indicate the source of goods and services. So throughout the United States, there are 5 offices that represent the United States Patent and Trademark Office. Of course, our USPTO headquarters is in the greater Washington metropolitan area, and that is where it all started with the United States Patent and Trademark Office. The first office that was open outside of the Washington metropolitan area was the office in Detroit, and it opened in July of 2012. And it is the only office that actually has a name. And our name, as I have stated, is the Elijah J. McCoy Midwest Regional USPTO. The second office to open was the Rocky Mountain Regional Office, which opened in Denver, Colorado. And that office opened in July of 2014. And that was followed in 2015 by the opening of the Silicon Valley West Coast Regional Office, and then subsequently the Texas Regional Office. These offices represent the USPTO in each and every time zone in the continental United States. So we move forward in this discussion and in this presentation with an identification of what intellectual property actually is. Just like a fence that surrounds a home or provides a physical boundary of property that might belong to you, intellectual property defines the metes and bounds of a legal fence around intangible property like a concept or an idea. So metes and bounds is a surveyor's term, a term that's actually used in measuring real property to determine what's included within the boundaries of a legal piece of land. And so we use that same term as we discuss and talk about intellectual property. So IP is ownership of a concept or an idea rather than ownership of a parcel or a property or an object. Ownership of intellectual property allows its owners to exclude other people from using the ideas or concepts that comprise the intellectual property at issue. So there are, what we will review today, 4 types of intellectual property. They are patents, trademarks, copyrights, and trade secrets. So a patent may be used to protect new and inventive ideas. For example, maybe your new inventive idea is for a charging station or a solar array. A patent may be used to exclude others from practicing that invention for charging a car or using a power source to charge a device or a solar array. A trademark or service mark identifies the origin of goods or the origin of services. In this sense, trademarks protect brands as well as consumers. Next, we have copyrights. A copyright protects creative expression stored in a tangible form, such as music, movies, or literature. These kinds of works are inherently difficult to create initially, but easy to copyright. For example, digital music or photocopies of magazine articles or books. Lastly, we have trade secrets. A trade secret is any information that is valuable and kept confidential, such as the formula for Coca-Cola or for WD-40 or for KFC. The first type of intellectual property that we will go into will be patents. I'm going to ask everyone to excuse me for a really quick second because my computer is about to go off. And if I do not reconnect myself, I will be disconnected today. And I do not want that to happen to me. Okay. Thank you for your patience. And I am reconnected. All right, so what is a patent? A patent is a property right. It gives the patent owner the right to exclude others from making, using, selling, or offering for sale, or importing the claimed invention. A patent has a limited term depending on the type of patent that you are granted. The term is limited to 15 or 20 years. Patent protection is territorial, meaning that protection is limited to the territory where the patent was granted. There are no worldwide patents. For example, if you would like protection in the United States, you would need to file your application for patent protection in the United States. If you were filing in Canada or in Mexico or in China, you would need to file a patent application with the patent office in each of these recognized territories that have patent offices for your protection. As I mentioned earlier, the United States Patent and Trademark Office is fostering innovation. That is our mission. The United States government grants this property right in exchange for disclosure of the invention, where you go in and you explain what your invention is about. You will disclose what your invention is. You will teach how to make and you will teach how to use that invention. As a patent examiner, one of the primary duties that they provide is ensuring that inventions are disclosed with sufficient detail, meaning that all of the statutes that establish how and why something may be patented are adhered to, and that the stakeholder who is seeking a patent has met the burden of satisfying all of those statutes. Types of patents. There are 3 types of patents. There are utility patents, there are design patents, and there are plant patents. Utility patents protect how an invention works, how an invention functions, or how an invention is made. The protection for a utility patent lasts 20 years from the filing date. A utility patent may be directed to a process, a machine, an article of manufacture, or a composition of matter. Design patents protect the way a product or an article looks. Protection for design patents lasts 15 years from the date of the grant of the design patent. Lastly, we have plant patents. Plant patents protect newly invented strains of asexually reproducing flowering plants, fruit trees, and other hybrid plants, and protection lasts for 20 years from the filing date. You may ask, what are some of the benefits? Why would I file a patent? Why would I get a patent? What's the big deal about getting a patent? Well, there are quite a few notable benefits for filing a patent. You can gain entry into a market. It provides the exclusionary right to the patent owner. A patent gives the patent owner the right to exclude others from making it, using it, selling it, offering it for sale, or importing that claimed invention or the invention in a patent owner's patent. This exclusivity may be a benefit for gaining entry into markets, deterring others from entering a market, and asserting and or enforcing rights against an infringer. Patents are property and may be used like other property assets to obtain funding, using patents as collateral. Patents can also be used to create revenue. Patents may be sold or licensed like other property. A business may be developed around an invention. And finally, patents may be used as a marketing tool to promote unique aspects of a product. So what is patentable? Patentability is governed by laws passed by Congress called statutes. I mentioned them earlier. So the outer circle in the diagram in the slide shows the types of inventions that may be patentable. An invention may be drawn to a product or a chemical composition, a method of making or using a product or a chemical composition, and improvements thereof. These are referred to as the statutory classes of invention. In addition to being a statutory invention, an invention must also be new or unobvious, useful, and clearly described. A major part of the job of patent examiners is to determine if an application meets these statutory requirements and communicating their findings regarding what's disclosed in the patent application as it is related to the statutes to applicant, to allow them to have a clear understanding of whether or not what they are presenting and what they have submitted is actually patentable. So what defines the patent grant for a patent? What defines the patent grant is the claims. The name of the game is the claims. The claims are what you specifically articulate you are claiming, or what specifically is your invention, okay? Knowing this, one of the potential problems of claiming an invention might be that you claim it so broadly that a patent examiner may be more likely to find a similar invention during a search or as they go out to find out whether or not your invention is new and unique. And if they find something that conflicts with what you are claiming, they will reject your application. This reduces the chances for you to obtain a patent. On the other hand, claiming the invention so narrowly that others would not have the specificity in the claims that you have or you may present, you might find that a simple modification might change a narrow claim so significantly that it gets around exactly what is disclosed. However, if the invention is claimed too narrowly, the invention may not be as valuable and the concepts may not be completely covered as you would need them. So ideally, what you would do is you would walk a fine line and you would define your claim scope in a manner that would be specific enough to articulate that which is patentable and broad enough to encompass the gray area around what would be obvious and what would be some modifications that you would make. For example, you may claim your invention and say that you're using a metal, but some of the different types of metals that are available might weigh into what makes your invention patentable. You may need a soft metal, or you may need a malleable metal. So I would direct you to taking the time out to look at what the variations may be within the scope of your invention. Trademarks. What is a trademark? Well, a trademark is a name brand. A trademark or service mark includes any word, name, symbol, device, sound, color, or any combination used to or intended to be used to identify and distinguish the goods and services of one seller or provider from those of others, and to indicate the source of the goods and services. What immediately comes to mind for me is if you've ever watched a Western and you look at the branding of cattle so that different people understand exactly whose cow is whose cow when we're out on the broad range and animals are roaming free and somebody wants to know what's my property. So that I can identify the source of the property that I am the source for, so that I can identify my cows, I may have a circle with a single bar that goes through it. And so I'm Circle Bar Ranch. And someone may come along and have a circle double bar ranch. And they may then decide, well, let's fill in the space between our two very narrow bars. And it'll look so much like the Circle Bar Ranch that we can't even tell the difference. And so then we can, if we do that, then we might be able to get some of their cows and bring them over to our side. And nobody would know whose product is whose, or whose cow belongs to who. So this has always been a bone of contention, and it has always been something that's serious. Understanding and knowing the source of a product is critical and key, not only to the consumer, but also to the owner. A trademark is not a business license. You need to check state and local regulations regarding requirements for business formation and operation. So again, I will recap. A trademark or a service mark includes any word, name, symbol, device, sound, color. I'm going to throw in smell, or any other any combination thereof used or intended to be used to identify and distinguish the goods and services of one seller or provider from those over others, and to indicate the source of those goods and services. Examples: the Tiffany blue is a registered trademark for Tiffany. Tiffany and Company's blue color is trademarked. I'm looking around to see if I have anything Tiffany blue in my office that I can show you, but if you're lucky, you've received a Tiffany blue box and you know that color when you see it. So a trademark is a brand name. A trademark or service mark includes, I've already said that, I won't repeat that. IP rights allow us to protect and control how our inventions, distinctive names and brands, original writings, and artwork are used. They also provide us with guidelines for use of other people's intellectual property. Federally registered trademarks. Federal registration of a trademark at the USPTO is not required, but it brings several benefits. A significant benefit is nationwide protection. Protection at the state level depends on use and enforcement in each state. Another benefit is the right to use the federal registration symbol, which is an encircled R. The other two symbols you can use are little capital letters TM or SM. These are the symbols you should use before you file a trademark application or during the application process. Excuse me. The small capital T, capital M next to each other stands for trademark. A trademark is a mark that represents goods like clothing or sunglasses. This symbol indicates that you are claiming rights within the mark and will potentially deter others from using it. Additionally, the TM symbol can provide common law trademark rights to the user. This is the symbol you should use while you are waiting for your application to be reviewed by the USPTO in your quest for obtaining a federal registration. SM stands for service mark. Service marks are marks that represent services. Another benefit of federal registration in the trademark realm is the right to record your mark with customs and use anti-counterfeiting remedies. The right to record your mark with customs is significant because it gives a right to block importation and in some instances seize counterfeit goods before they are able to come into the United States. Federally registered trademarks may also serve as a basis for foreign filings. Federally registered trademarks are also published in the United States Trademark Database. While you can file an intent to use application at the USPTO, trademark owners need to use the mark in commerce in order to retain that protection. You can't just think up a great name for a product and own it forever without actually using it. Again, the mark must be used in commerce in order to retain protection. You have to use it. Okay. The USPTO provides a free training series that we call Trademark Basics Bootcamp, and it's offered throughout the calendar year. We will be having a new session or a virtual session coming up that will be placed in the chat for you so that you can plan accordingly. Copyrights. While the Copyright Office is not a part of the United States Patent and Trademark Office, but is a part of the Library of Congress, the Undersecretary of Commerce for Intellectual Property, the Director of the United States Patent and Trademark, has oversight authority and advises on copyrights. Copyrights protect original works of authorship, including literary, musical, dramatic, artistic, and other works fixed in a tangible medium. Generally, the term of a copyright is good for the life of the person who developed the IP plus 70 years. This time was extended from 50 years to 70 years in the Copyright Term Extension Act of 1998. Anything you write down, anything you paint, photographs that you take, etc., these are copyrighted, but it needs to be protected by registration with the Library of Congress to gain strong protection under the law. The encircled C symbol can be used without registration. So just to recap, there are 3 symbols that you can use without registration. The capital T and capital M that you see for trademark, really small next to various things. Also, the SM, which is for service marks, where it could be a carpet cleaning business or the like. That's also utilizable without registration. And the circle C can also be used under the copyright symbol that you see here without registration. Things protected by copyrights. Things protected by copyrights, as I've stated, I believe already, include songs, books, sculptures, movies, and sounds. Okay, all right. So we've expanded our horizons artistically, we've expanded our horizons regarding copyrights, and now we move into the trade secrets. So the question becomes, as I've asked, what's a patent? What's a trademark? What's a copyright? What is a trade secret? Well, a trade secret is any information that derives economic value for being not publicly known or ascertainable. So it's a secret. It's something that's kept from the public's eye. A trade secret can be a formula. It can be a pattern. It can be compilations. It can be programs, devices, methods, techniques, or processes. All states have some sort of trade secret protection. Trade secret protection stems from common law of the 1800s, but most states use the Uniform Trade Secrets Act to form the basis of their laws. In contrast to patents, trademarks, and copyrights being regulated by federal law, trade secrets are primarily maintained through state laws. Although primarily maintained by state laws, there are also provisions at the federal level. In 2016, the Defend Trade Act was signed into law, creating a federal cause of action for misappropriation of trade secrets. There's also the There's also the theft of trade secrets which is found in and codified in 18 USC 1832. Let me say that real fast 5 times. So of note regarding trade secrets, in August of 2020, an Uber executive was sentenced to 1.5 years in jail for trade secret theft from Google. And just last month, month before last, in March 2022, luxury jeweler Cartier sued Tiffany & Company, accused of stealing trade secrets concerning its high-end jewelry from an employee Tiffany lured away from Cartier. Examples of trade secrets. Here are a few that you may be familiar with. The secret formula for Coca-Cola. Nobody knows what it is. KFC's original recipe. Delicious, but also unknown to the public. The lubricant formulation that provides WD-40. What's in that stuff? And Listerine. Listerine can not only be used to clear your breath, but did you know Listerine can be used to clear your head of dandruff? Amazing. The special sauce on a Big Mac, that's something else. And the formula and the formulation and the creation of a work of art, the Krispy Kreme donut. Trade secrets may also be used to protect software. So why are trade secrets so useful? Well, trade secrets protect commercially valuable proprietary information that gives a competitive advantage and edge. A trade secret may be used to protect things such as customer lists, product formulations, and search algorithms. Trade secrets are not generally known and must be subject to reasonable efforts to preserve confidentiality. Trade secrets may be used to prevent employees and contractors from disclosing your secrets to competitors and the public. Another benefit of trade secrets is there is no set term for protection. So if there's no set term for protection, how do you lose a trade secret? Well, what I would say is the first way is failure to take adequate steps to protect the disclosure. You can't leave the formula sitting on your desk, or you can't, walk around with what the secret is where someone in the public or someone who might be interested might have the ability to gain access to it. So failure to take the adequate steps to prevent disclosure. For example, failure to protect the secret. Do you have rigorous procedures to maintain an item as a secret? Is it locked in cabinets? Is it in an encrypted file? Is it double password protected? Have you established non-disclosure agreements with your employees where they are bound by law not to discuss what they do know about your secret? Or contracts or written policies with employees and contractors who may gain access and or acquire knowledge as to what your actual trade secret is. You've got to keep it secret. Another way to lose your trade secret is if you choose to disclose it. Owner or owner authorized disclosure could result in you losing that competitive edge or that proprietary knowledge that gives you that advantage. Reverse engineering. It is possible and it could happen that someone playing around in a lab could come up with a special sauce that tastes so similarly to the special sauce on a Big Mac that you or someone else might not be able to discern the difference. If you did reverse engineer and discover the trade secret, it's no longer a secret, okay? And then there could be independent development. It may also be possible for someone without insider knowledge to independently discover and develop your trade secret or develop something that could serve as a trade secret and they could use it for their gain. You may be asking yourself, is it therefore better to keep innovations as trade secrets? Remember, the constitutional purpose of patents is to promote the progress of science and useful arts, to advance them in a way that would be beneficial to all. If we keep all things secret, the progress of the useful arts would be slowed and stilted. It is a business decision, and there are times when the use of trade secrets are proved to be warranted, such as with Coca-Cola or with the KFC or the WD-40 formulations and recipes. So I'd like to go over and recap the extensive panoply of intellectual property that I have gone into. I'm going to recap these quickly, and then we will turn our attention to any questions that you may have put in the chat that we have yet to answer. So a recap of intellectual property discussed today includes the 3 types of patents, which are the utility patent, the design patent, and the plant patent. Okay, utility patents such as the iPod, chemical fertilizer, or a process of manipulating genetic traits in mice. Protection for utility patents lasts 20 years. We have design patents that protect the way a product or an article looks, such as the unique shape of an electric guitar, or the design for a lamp, or the tread of a tire, or the design for a sneaker. This protection lasts for 15 years from the date of issue. And then there are those plant patents, protected newly invented strains of asexually reproducing flowering plants. And protection for these inventions lasts for 20 years from the date of filing. I also delved into a discussion regarding copyrights, which protect original works of authorship that include literary, dramatic, musical, artistic, and any other work fixed in a tangible medium, such as Michael Jackson's Thriller, music, artwork, and video, or the Windows operating system. Generally, the term of a copyright is good for the life of the person who developed the IP, plus 70 years. However, for some works, 95 years from publication, and others 120 years from creation. Furthermore, I discussed trade secrets, and trade secrets protect things such as formulas, methods, devices, compilations, or any of the information which is used and can be used to give a business advantage or a business edge. An example would be the Coca-Cola formula, the WD formula, the Big Mac formula, the Listerine formula. This type of protection, these trade secrets, they last as long as the information remains confidential and functions as a trade secret. Last but not least, we discussed trademarks, and trademarks protect words, symbols, logos, designs, or slogans that identify and distinguish products or services, such as the Coca-Cola name and its distinctive logo. Protection lasts for as long as the mark is in continuous use in connection with goods or services. However, please note that a trademark must be renewed by year 6, 10, and thereafter every 10 years. So there is a maintenance and or a responsibility to renew your trademark registration with the United States Patent and Trademark Office. IP as a business structure, as a business strategy. Understand that having an intellectual property strategy is in and of itself a business strategy, okay? IP ownership is a property right that can add value to the assets of a company. It's attractive to investors and buyers. You watch Shark Tank and they ask, well, do you have any intellectual property? Do you have a patent? Do you have IP protection? They ask these questions because these questions are part of a business strategy. When these sharks are interested in buying, they want to know how much strategy have you employed in setting up this business or in establishing this business. So an IP strategy is attractive to investors and buyers. It can defer infringement lawsuits. If you have the protection, it can keep others from asserting that you have their intellectual property, because your intellectual property is registered and on the books and recognized. It can increase leveraging power for mergers and acquisitions. You know, I'm a big company and a small company has an incredibly powerful patent that if I got that patent and combined it with the patents in my own portfolio, it would expand my ability in the market to exert a stronger business influence. So, you know, we can't impress upon you enough that the Small Business Administration and SBDCs and SCORE offices throughout the country help you to step back from being so rigid and narrow-minded in your intellectual property thought process to stand back and look and see how you might establish a business strategy as it relates to your IP. So assessing your company's IP assets and prioritizing them, knowing your competition and what they're up to and what's in their portfolio is important and significant in the development of this strategy. What's the pace of innovation and opportunities for growth? If you have a cutting edge limitation, or you have a cutting edge property or principle that you want to advance and you want to protect, that's going to give you a leg up on your competition, then that's critical and important with regard to the pace of innovation and opportunities for growth. Determine the best way to protect your IP. You might benefit from multiple types of intellectual property. It might be a patent and a trademark that you need, or you might want to employ a trade secret and a trademark, or you might want to use some combination or any combination of the 4 types of intellectual property that I have articulated and discussed this afternoon. But in any event, what we do encourage you to do is develop a plan, set goals, and implement a winning strategy. When you are at your wit's end and you don't know which way to go, get help. There is all manner of help. There is the Small Business Administration. There is the United States Patent and Trademark Office. Although we can't give you legal advice, we can assist you and help you in making a determination as in the way to go or what type of intellectual property you might need. For example, we have an IP assessment tool that I would encourage you to consider utilizing. Okay, this tool will, if you go in and you answer these questions, this tool will allows you to gauge your intellectual property awareness. And once you click through the assessment, you will receive customized training materials that are directed towards the answers that you gave regarding where you're moving in the intellectual property space. 2 of the topics of particular interest are licensing and technology to others and using the technology of others. You will learn more about these 2 amongst others by using this tool. I've seen in the chat a little bit of chatter about the patent public search tool. This tool provides more convenient, remote, and robust full text search of all US patents and published patent applications. You want to engage in a search to see whether or not something you believe is a creation of your mind has already and exists in the public's eye as a creation of someone else's. You don't want to waste your time. You don't want to waste your resources. You don't want to waste your energies pursuing something that you cannot protect. You cannot get a patent if your invention has already been publicly disclosed. Therefore, a search of all previous public disclosures, foreign patents, and printed publications should be conducted. This tool was designed to help you get started. This patent public search tool. Patent public search tool benefits include free cloud-based platform, text searching, optical character recognition, scanned back to patents issued prior to 1976. And it gives the user the option of multiple layouts with multiple tools to view more data at once as it relates to public searching and investigating an invention, or what you believe might be your invention as it relates to what's disclosed in the public. Patent public search tool can be found under free services, and it can be found in a lot of the information that is on the slide here before you. So this is a new page. This free access, free services page is a new page to help you look for different types of IP resources. We received feedback from our stakeholders, and we created this to consolidate all of our resources. So this access to our free services at the USPTO is a result of the direct feedback that we're getting from stakeholders such as yourself. So when you're asked to do a survey or you're asked to give us your opinion, it really does matter, and it really does shape how we engage and how we interact. Okay. We are coming down to the very end of the presentation, and something that we would love to do in the very near future in one of these sessions is to come back and walk you through a demonstration of our new free services page and point out the most popular links, and give you an idea of what the resources are that USPTO has and wants to share that would allow you the opportunity to expand your understanding and knowledge of intellectual property in patents, in trademarks, in copyrights and trade secrets. So I am going to stop and take a breath, and I am going to look and ask my colleagues who have been diligently putting information in the chat and responding to questions and answers that have been advanced by you. So let's see, are there any questions that we need to turn our attention to that you haven't answered, team?
I believe we answered everything that was in the question and answer box.
Fantastic. So I'm going to ask, can you reverse an abandoned trademark application? Can you reverse it? You can certainly petition to see whether or not it can be reviewed and whether or not it was improperly abandoned. I know on the patent side, we have mechanisms that would allow for you, if it was unavoidable or unintentional, to have an abandonment reviewed, looked at, and assessed as to whether or not it needed to be overturned. That's a great question. And it's a question that we will, if you put your information in the chat, we'll get that back to you. I believe that Elena Dent has offered some information in the chat regarding that question. Are there any additional questions or any suggestions or any comments that you'd like to share with us? We are available and we're here and we'd like to hear from you. I see a question in the box about trademark law litigation.
Mm-hmm.
I don't know that the litigation has changed, but intellectual property law is always governed by the decisions made by the court and the legal precepts and concepts that establish the statutes. So how has it changed? Intellectual property is dynamic, always changing, and is so up to the minute. So we are trained and we are constantly alerted to modifications, changes, and those decisions that are made that impact how we do what we do on the patent side and on the trademark side. We don't get into a lot of law litigation as we don't give legal advice, but a discussion with a trademark attorney might be an opportunity, and someone who's practicing on the outside give you an opportunity to ask that question and to make an analysis and an assessment. I'm curious, Alan, as to whether or not you believe that trademark law litigation has changed over the last 20 years, if you've been engaged in trademark law litigation for that long a period of time. Might there be any additional questions, team?
That looks like about it. This has been great, James. I mean, you've got a ton of information and got some links to share a lot of the resources. We'll compile all this also and send the replay back out to everybody once we process the data and stuff. But James and everybody else for showing up today, I really appreciate it. Everybody in your team, James, you guys were spectacular. I know you guys are going to get to another one here in just a couple seconds. So I really appreciate your time today. You've answered a ton of my questions, and I really appreciate you doing this for us.
Well, David, know this. We are and we stand at the ready to provide you with any level of assistance that we can as it falls within the purview of the United States Patent and Trademark Office. You call us back, we're coming back.
All right.
You ask for specific things, we're going to do what we can to provide you with the level of support that the United States Patent and Trademark Office is noted for in the federal government. So we thank you so much for taking time out of your schedule to invite us and to have us here. My team relishes the questions and they love the opportunity to dive in and to give clear guidance to our stakeholders and your stakeholders. So again, we thank you. And for anyone who is still on the line and still in the box and receiving chats and have opportunities to do the Q&A, reach out to us. We're at Midwest region at USPTO.gov. Someone please put that in the chat. And we are looking forward to spending time with the stakeholders in the state of Kentucky throughout the remainder of this year. And again, David, thank you so much. Team, thank you for the excellent job that you do and you always do. Everyone stay safe and have an amazing evening. Happy belated Mother's Day to everyone. And let's hope that we have a great end of this spring and summer as we move forward and further and deeper into 2022.
Absolutely.
Thank you so much.
Thanks, team. Goodbye, everybody. We'll see you next time.
Bye-bye.
Bye.